but they are choices that American legislators, who are at least as committed to traditional American values as judges, are rarely tempted to make. The result is that an unconstitutional law is extremely rare. If judicial review were what it purports to be, the invalidation of policy choices clearly prohibited by the Constitution, isn't that what it purports to be? It would be a matter of little more than academic interest. I say clearly because in a democracy, the opinion of elected legislators should prevail over that of unelected judges in cases of doubt. The freedom of speech guarantee of the First Amendment presents the problem that it cannot mean what it says unless it is interpreted very narrowly to prohibit, for example, only prior restraint on publication. Government must be able to, and does, abridge the freedom of speech in many ways: perjury, solicitation of crime, false advertising, agreements and restraint of trade, and so on. The result is that the court's freedom of speech decisions do not involve constitutional interpretation any more than its due process and equal protection decisions. Roe v. Wade is not the only example of its old policy. All rulings of unconstitutionality are that. The result, it is not the First Amendment, I hope it's perfectly clear, even if incorporating the 14th, that restrains the states from prohibiting nude dancing, right? Most people reading that don't come to that conclusion. Prohibiting flag burning, armbands in schoolrooms, parading vulgarities through a courthouse. That's all in interpreting the First Amendment. Except for Justice Kennedy's vote, it would not even prohibit the federal government from limiting corporate campaign contributions. Similarly, it's not the Establishment Clause of the First Amendment that prohibits the states from providing maps and magazines to parochial schools, but allows the states to provide books. It's all written there if you read it right. The same is true of the rest of the Bill of Rights, involving mostly criminal procedure. The Fifth Amendment, for example, provides no person shall be, quote, twice put in jeopardy for the same offense, unquote. This does not mean, of course, that a defendant cannot be retried, for example, after a hung jury or a reversal of a conviction on appeal. Of course, they're retried. But neither does it mean that although the defendant may appeal a conviction, the state may not appeal an acquittal. It doesn't mean that, as was pointed out, for example, by Justice Holmes, who, studying of common law, put him in a position to know, and which was in fact held by unanimous court in an opinion by Justice Cardozo. The state can appeal, but this decision was reversed by the Warren Court in an opinion by Justice Thurgood Marshall. Now, do you think that was because they had a different interpretation, and a clearly mistaken one, actually, of the double jeopardy clause? No, it was only because of a different attitude in the 60s toward enforcement of the criminal law. As I take it, is obvious everywhere except in gatherings of constitutional law professors. It would be very difficult to find a ruling of unconstitutionality by the court that can realistically be said to turn on constitutional interpretation. Virginia didn't lose the right to operate an all-male military school because Justice Ginsburg read the Equal Protection Clause. Texas didn't lose the right to prohibit sodomy because Justice Kennedy had a new insight into the meaning of due process. That's preposterous. And yet we say it as if we're in some kind of a wonderland here. But how about the District of Columbia v. Heller, the gun control case? Now that must involve some interpretation, right? Both Scalia, for the 5-member majority invalidating the law, and Justice Stevens, for the dissent, engaged in extensive historical research on the issue of whether the Second Amendment guarantees an individual right to possess firearms. Each purported to interpret the Second Amendment. And by a happy coincidence, their opposite interpretations coincided with their policy preferences. That's just how you interpret. But that, of course, is what always happens. Is it not clear when you get the same 5-4 split on every issue along ideological grounds, regardless of the issue? You get that split? Because they interpret differently? The result of judicial review, it should be too clear for argument, is not judicially enforced constitutionalism, but rather the court being the policymaker on any issue it chooses to remove from the ordinary political process, obscenity, libel, anything else, it chooses to remove to the ordinary political process and assign for final decision to itself. That's all. It has given us a system of government similar to that of Iran. There, as here, people vote to elect legislators who pass laws. But it's the Grand Ayatollah who decides which laws go into effect, a function performed here for us by Justice Kennedy. You see the parallel? It's the very same system. The difference is that the Ayatollah's power comes from his theological authority, while Kennedy has none. And so he has to pretend to be interpreting the Constitution. For whose benefit? Who is he kidding? My fellow panelists. He's certainly kidding Barnett. Barnett swallows that gulp every time. Our need is not to debate methods of interpreting the Constitution, but to inform the American people that nothing is being interpreted, that the Constitution is not being enforced but perverted, and only, at least until recently, perverted only to push policy choices to the left. Finally, though you may not realize it, I have answered my assigned question. Does originalism always provide the answer? The answer to that question is yes. It provides the answer, and the answer is always no. As clear as can be. The challenge law is not unconstitutional. The Constitution does not, in fact, clearly preclude the challenged policy choice. And isn't that the issue? On the issue of originalism, I think it is necessary, I don't think it's necessary to say any more than that there is a difference between reading and writing, between receiving and sending a communication. The two basic objections are made to originalism in constitutional interpretation are, first, that we may not know the ratifier's intent or understanding to a contemporary issue, or more realistically, they probably never considered the issue. And second, why in any event should we be bound by the dead hand of the past, as Jefferson, for one, put it? And the answer, of course, is that if we don't know that a policy choice has been clearly precluded, the only proper conclusion is that it's not precluded. And the dead hand objection is an objection to constitutionalism. And it's a good and valid objection, but not to originalism. Neither objection leads to Justice Brennan's conclusion that judges may therefore declare laws unconstitutional on a non-constitutional basis. The real objection to originalism, as Justice Brennan was candid enough to make clear, is not that it doesn't answer constitutional questions, but that it gives the wrong answer, leaving judges with too little to do, and raising the nightmare of the American intellectual, public policy falling into the hands of the American people. What kind of a country would this be? Right? You know, we'd have capital punishment, we'd have prayer in the schools, we wouldn't have Miranda rules. Could you live in that country? My colleagues can't. Thank God that Brennan has saved us from all those horrors. The faith in democracy, Justice Brennan said, is one thing. Blind faith is quite another. Liberals do not suffer from an excessive faith in democracy. The issue, to repeat, is not how to interpret the Constitution, but simply who is to govern. Thank you.